Welcome everybody. My name is Jeff Fowler with the Apartment Owners Association, and today we're going to cover how much you can raise the rent in the Bay Area. And so before we get started, just want to introduce AOA to you. We've been around for over 40 years, and we're one of the largest individually organized groups of apartment owners here in the state of California. And we have an office in Alameda, and we are looking to give you information that will help you do the right thing, stay out of trouble, and hopefully have a better return on your investment on your real estate property. So that's what we're here for, and we realize that what you don't know may cost you a fortune. So if you're not a member, it's only $97 to join for a year, and you get the magazine, you get the property management advice hotline, all the free forms, and so much more. So definitely want to invite you to do that. And yeah, so here we go as we get started. I've heard just today, I heard that in San Anselmo, and I don't even know if I'm saying that correctly, but they had a meeting on Tuesday night, and they're looking at creating rent control and vacant or eviction control laws for that city. And so that's something where we're going to be looking into that and trying to rally the troops who own property there to show up at the next city council meeting. And really we do the political action just as grassroots. We find out about things, and we try to mobilize all of you to fight for your property rights. And so we'll keep you posted on that for sure. And then also February 16th, we have the Landlording Power Conference that's coming up in Santa Clara, and we'll have multiple speakers and vendors there, and that should be just a great time to sharpen the axe, so to speak, and hopefully you'll come away with ideas that will really help you manage your properties more effectively and hopefully increase your bottom line. So if you are a rental property owner, I encourage you to subscribe to this channel if you haven't already. If you're an AOA member, subscribe. Not everything we put on this that we post here shows up first as an AOA event, so subscribe and then you'll make sure you catch everything. All right, and so our speaker today, we'll get into it. Our speaker today, he has over 30 years of experience. He's the founder of Beckman, Feller and Chang. He does real estate and landlord-tenant law. So he does multifaceted there, but of course it includes evictions. And his firm represents 7 Bay Area counties. And I love his article that he writes every month in the AOA magazine, the Legal Q&A. So just so thankful for our speaker and the way that he has patiently taken calls and written articles and even taken the time to jump on with us today. So it's my pleasure to introduce to you today Richard Beckman.
Words. And I think you were trying to say San Anselmo, which is a small town in Marin County near where I live, in the even smaller town of Woodacre. Marin, is not impervious to the pressures of tenant advocates seeking, additional rent control beyond the state law. It has been one of the last places to see that kind of push, I think partly because there's not quite as much of a rental population in Marin County as there is in San Francisco or East Bay counties. But a little town called Fairfax passed a similar ordinance. So it's the coming tide. But again, they're not much different from the statewide rent control, AB 1482, the Tenant Protection Act from 2019. They generally try to restrict rent increases below what the state law allows, which is 5% plus the CPI, which in the last year has totaled about 10%. And so, that's kind of the biggest push. I feel like the state law is too lenient. But we're not here to talk about that. We're here to talk about the agenda on what can I do with rent increases. And so I be honest, this one came to me a little bit later than I tend to prepare. And so I had an assistant help me prepare. I've learned some things that I didn't know. So we'll go on this journey together in some cases for the first time. So I'm going to share my screen and bring up a PowerPoint presentation, hopefully, and we will take it from there. All right. All right, with any luck, you're now staring at my screen that says, how much can I raise the rent in the Bay Area right now? And the Bay Area is for those of you who are, more southern located, is the San Francisco Bay Area, mostly considered San Francisco City and County because it's one and the same. Marin County to the north, the East Bay, which is mostly Alameda County to the east, and then Contra Costa County is not touching the Bay, but it's, I think most people would consider part of the Bay Area, and then down the peninsula to San Mateo and Santa Clara. So we're going to talk mostly, though, about the East Bay cities and San Francisco. And that should give you a flavor of what you're looking at. So moving right along through the presentation, the agenda, which is how I like to organize my presentations. What do I need to do before I serve a rent increase? This is where I got a little bit of education myself, because generally, historically, nothing would be the answer. You just need to make sure that the tenant was not on a term lease, which locks in a rate for the length of the term, usually a 1-year term. But when tenants are month to month, typically there's no prep for a rent increase notice. You just serve one. But that is now not necessarily the case. And so we're going to start with Berkeley, and a little bit of background is just and I do recommend everybody become acquainted with the local rent board website in whatever jurisdiction their property is located in, because those rent board websites can be very, very helpful. They do their best to make clear, concise information available both to landlords and tenants. And in some cases, there's required information that is provided there. So I really recommend that you become familiar with your local rent board website. So in Berkeley, they, like everybody, they pass an annual general adjustment. Not everybody calls it that. Berkeley calls it that. So AGA. And that is effective on January 1st, so that rent increases can take effect as of January 1st. And that's going to make a little more sense in just a moment. So the AGA here is set by 65% of the consumer price index. Because again, some of the rent ordinances allow full inflation rate, and some do a percentage of the inflation rate. So when you're talking 65% of the consumer price index, you're not even staying up with inflation. So I think that is a little worrisome, because it should be at least tracking inflation, and it doesn't have to be the state law, which is 5% plus the inflation rate, but to just allow 65%, but that's not uncommon. So here's the part that's a little bit weird about Berkeley. I don't think there's any other jurisdiction that has anything quite like this. So, and this is from their website. So if you don't, get it here, you can check there. But basically, you can't raise the rent, and I'm just reading this, for the rest of the year in which the tenancy started, and for one additional calendar year. For example, tenancy starts on March 1st, 2023. The landlord cannot raise the rent for the rest of 2023 or in 2024. So you can do your first rent increase of January 1st of 2025, assuming, with proper notice, which we're also going to talk about. But I don't know of any other jurisdiction that has that kind of restriction, meaning if you rent to somebody in January, it's almost 2 full years before you can give a rent increase. And that's just kind of bonkers to me. And I'll be honest, I did not know that. So this presentation has been informative both for me and the staff that helped me put it together. So, but again, we can't do anything but observe the law. I mean, you can try to get it changed through the advocacy that Jeff mentioned, but otherwise, you just got to follow it. So that's the Berkeley situation. Now, when you talk about what do I need to do before I can serve a rent increase, you cannot take the rent increase unless all of these things have been complied with. You have to have paid your rent board registration fees. Make sure there's no order from the rent board denying rent increases because of some sort of petition of substandard housing. There are no serious repair problems or outstanding housing code violations. Here's one that you got to kind of keep an eye on. The landlord has failed to pay interest on the security deposit for the unit. So you got to make sure that that's done when it's due, or else the tenant can reject the rent increase. And then finally, of course, if the tenant has a fixed term lease, you have to wait until the lease expires, plus any other amount of time that the Berkeley ordinance requires under that first section we just talked about. And so that's Berkeley. Moving to Oakland. So this is one that I think trips up a few people. The tenant has to get this, what we call the wrap notice. And they're supposed to get that when they move in. And they are supposed to give a copy with any rent increase. And it explains the existence of the rent board and the tenant's rights. And so there are consequences for not doing that. If you don't give the wrap notice, you can't increase the rent until 6 months after you've given that notice. So you want to make sure for all you Oakland property owners that your tenant has been given the wrap notice. And if they haven't, you make sure that you do it, and then you calendar 6 months before you can do a rent increase notice. And also, this is a relatively new thing, the Oakland Rent Registry. We talked about this, I think, in a couple of prior seminars. If you fail to do it, then it's defense to an unlawful detainer. So, it's really important that you make sure that it's registered, but it also affects your ability to do a rent increase. So if you fail to comply, you will forfeit 6 months of a rent increase unless you cure the failure to register. Now, I don't fully understand that. So the rental property owner may cure the failure to register and not be subject to a forfeiture of a rent increase if the owner substantially complies with the registration 6 months prior to serving the rent increase notice. So it's like the wrap notice. If this stuff is not done, you're gonna wait 6 months before you can do a rent increase. So in Oakland, you got to make sure your tenant has received the wrap notice and that you have registered the unit on the rent board's website. So that's Oakland. San Francisco. This was new information to me. I did not realize this, so I'm glad we are doing this seminar. The landlord must get a rent increase license before imposing annual, allowable, or bank rent increases on a tenant. That started about 2 years ago, and somehow I missed that. I just, like, when I was reading this from my assistant who was preparing, like, what license? But if you go to their website, they'll explain it to you. And so it's basically, the rent boards want to know what's going on, what units are out there, what units are rented, and so on. So that is fully in effect now. So if you want to do a rent increase in San Francisco, you got to make sure you have your rent increase license issued by, I guess, the rent board. But again, I haven't had a chance to do a deep review on that. So I'm sorry, I inadvertently took us backward. So again, the San Francisco, like all the other rent board websites, have, all, generally speaking, pretty thorough explanation of these things. So it's one, you just got to be aware of it so that you know, and then secondly, you can get the details from the website. And Richmond, and I just copied, I wanted to cover these 4 sort of local major cities: San Francisco, Berkeley, Oakland, and now Richmond. And so in Richmond, you are required to provide tenants with a copy of the Richmond Rent Program brochure at the beginning of the tenancy and with each notice of rent increase. Similar to the Oakland wrap notice, you give it to them when they move in, and then you give it to them with any significant development like a rent increase notice. And again, Richmond has a good website. You can check it out there. Sorry, again, my thing is awfully sensitive today. So, anytime you have questions, and you have to go to the Richmond website anyway to do some of the registration that they also require. Now, the next item on the agenda was what type of notice. It's just basically a notice of rent increase is a pretty standard form. AOA has it on its list of forms. There's a Civil Code section 827 that governs notices of change of terms of tenancy generally, but also specifically as to rent increase notices. So that's the statute that describes what you do and what you can't do. Basically, it just says that if the rent increase is less than 10%, you only have to provide a 30-day written notice. And if the rent increase is more than 10%, you have to provide 90 days of notice. And Berkeley and Richmond both have forms of rent increase notices on their website. So generally speaking, if you're going to serve a rent increase in a rent control jurisdiction that provides a form, I probably recommend using their form because it should be pretty much safe harbor in terms of any of the issues that the tenant could raise. So if the jurisdiction provides a form, might as well use it. And now this is actually going to go much faster than it probably was a 30-minute presentation, but we can take some questions. How much can I raise the rent? So this is the other important part. First of all, what do I have to have in place before I can do a rent increase notice? And now, how much can I raise the rent? So again, going to Berkeley, they do their annual adjustment in October, and that becomes effective starting January 1st. And now, as we said earlier, it's 65%. The current AGA for 2023. So for any rent increases that would have taken effect between January 1st and the end of the year is 4.4%. And the Berkeley Rent Board has a calculator to allow the property owner to basically put in there and just get the calculation. I mean, I don't know that I think any little calculator will do the job, but you might want to look at that. It also has some different information. So, I would take a look at it at least. And then, of course, they have their own rent increase form. So, it'd be on their website anyway. And so there's that. That's how much you can raise the rent in Berkeley this year. And then I guess shortly we'll learn in fact, it probably, well, maybe they issue that new AGA at the end of October. But we can check back at the Berkeley website for that. Something you have to know about, and generally speaking, is what's called a banked rent increase. And I don't know how many people are familiar with this concept, but basically, it's a provision that allows a landlord to recapture prior rent increases that were not given to the tenant. And it happens. There are a fair number of property owners who, for one reason or another, do not impose an annual rent increase. Yeah, just don't get around to it, or want to, think the tenant's done a good job taking care of the place, want to reward that by not, imposing a rent increase, even though it would be legally allowed. So for whatever reason, and then if the owner changes his or her mind, the owner can impose what's called a banked rent increase. A little different in different jurisdictions, which we're going to cover briefly here. But the concept is basically you can go back and in time, and you can find out how much you could have increased the rent and do it with the next rent increase. So just be aware of the concept, bank rent increases. And in Berkeley, you can, because Berkeley has a published rent ceiling, and it includes the amount of the rent increases year after year. And so the amount that the rent board lists as the maximum rental ceiling may not be what you're charging because you haven't done any recent rent increases. So that rent board website, rent ceiling, tells you how high you can raise the rent by imposing these banked AGAs. And again, Berkeley website provides the form, so I would recommend using that, particularly if you're doing bank rent increases. In Oakland, it's a little different. The Oakland Rent Adjustment Program ordinance, it does, like everybody, allow an annual rent increase, and now theirs is based on the CPI. It, I think, was before too recently, it was based on the actual CPI, but now it is also becoming a percentage, right? The City Council adopted an amendment to change the formula to 60% or 3%, whichever is lower. So, you're never going to get more than 3%, which is, again, I mean, not even close to the rate of inflation, but hopefully inflation is coming down. So that's their rent increase comes out of August 1st, and then that will be the guideline for rent increases that take effect after August 1st. And this particular, for the next year, it's 2.5% in Oakland. And Oakland, right now, is still under a rent increase moratorium until the end of June of next year. And what that means is the only rent increases that are allowed are either your annual amount, the AGA, 2.5% in this case, or rent increases that are based on a petition alleging that the owner needs a higher increase in order to receive a fair return on investment. And that's a complicated concept, and a fairly complex petition, because you have to submit to the rent board evidence of your finances and why you're not getting you have a constitutional right of a fair return on your investment, and rent jurisdictions cannot prevent that through their rent increase limitations. But establishing that constitutional fair return, again, is not a simple matter. So, but it is an option. And the restriction on banked rent increases, or for example, other petition-based rent increases like increased operating expenses, that's the biggest one I can think of, will be allowed as of June 30th of next year. And then you can begin to seek or impose banked rent increases. But in Oakland, unlike, I say, there should be a slide here for this, but in Oakland, unlike San Francisco or Berkeley, does not allow a blanket bank rent increase to be imposed. Let's say you haven't increased the rent for 5 or 6 or 7 years, or you bought a place where it hadn't been, so the new owner wants to maximize that return. In San Francisco or Berkeley, you can do that increase all at one time. But in Oakland, the bank rent increase, if it exceeds more than 10%, has to be done in subsequent years. Let's say you've had a 5 or 6 years of no rent increases, and the total is 18%. Again, in San Francisco or Berkeley, you could just serve a rent increase of 18% and be done with it. In Oakland, you'd have to serve one bank rent increase for 10%, and then the next year you capture the remaining 7 or 8%, whatever I said, 17 or 18%. So that's that's just their way to try to lessen the impact, because it is a little surprising in San Francisco if you haven't done one, and it can add up to 30%, and suddenly the tenant gets a 30% rent increase. So I think the Oakland ordinance took that into account and said, I don't think we want to allow that, and then so they don't. Now in San Francisco, how much can I raise the rent effective March 1st? Because all of these jurisdictions, their adjustment date kicks in at different times. In San Francisco, it's effective March 1st, and so any rent increase that takes effect after March 1st until next year, I see next year as a leap year, is 3.6%, and again, it's based on 60% of the inflation index. But other than that, that's about all you need to know on that one. And bank rent increases in San Francisco, as I was just saying, you can impose the entire amount with one rent increase, and all the way back to April of 1982 for those of you who really been sleeping on your rent increases. And I would use it's just take all the percentages, add them up together, and that's your rent increase. Pretty straightforward. And how much can I raise the rent in Richmond? So their AGA takes effect on September 1st, and it is 3%. So any rent increases that take effect after September 1st of this year is limited to a 3% increase. And let's see, how much landlords in control shall file. Well, this is something that is also, unique, that you have to file a copy of your rent increase notice along with the proof of service with the rent board within 10 days of serving that notice on the tenant. Again, I don't know of any other jurisdiction that requires a copy of a rent increase notice to be provided to the rent board. So that's just something you got to be aware of, because if you don't, as it says, this is basically from their website, if the landlord does not file the rent board with the rent board, the notice and proof of service, the rent increase shall be deemed null and void. So, and again, half of this stuff goes under the radar and tenants don't know about it, but those that do, will certainly, make sure they check and see if you filed that copy with the rent board, and if not, they may just ignore it. You know, maybe they'll bring it to your attention. Maybe they'll just say, hey, you know, we understand, no big deal. We're happy to, you know, we like the place. We're happy to pay it. But, you know, I always try to take away any argument that the tenant might have by making sure that my client complies with all their obligations. Bank rent increases in Oakland. I'm learning this for the first time because I haven't really done any in Richmond. But here they say it shall be calculated based on compound addition. And this is an example that I was seeing for the first time. I think the Richmond Rent Board, you know, will provide some guidance on this as well. But an increase of 3% plus 3.4 turns out to not be 6.4, but 6.56 because it's compounded. And that's a sort of a banking term, compound interest thing. So, you know, but I would always err on the low end if I had any doubt about it. Because if your rent increase exceeds the amount you're allowed, of course, it's not going to be effective at all, regardless of anything else you do. So you might want to just, like I say, go to their website. If you're doing bank rent increases in Richmond, you might get more than you would have thought you're entitled to because of that compounding. Finally, I wanted to have my assistant put in a little nod to AB 1482, the Tenant Protection Act. That's the state law that went into effect in August of 2019 that basically imposed rent and eviction control statewide unless the property is in a jurisdiction that already has an existing and more tenant-friendly rent and eviction control law. But this is something, excuse me, if you're in a jurisdiction that doesn't have a local ordinance, and that's much of Alameda County, you know, outside the incorporated cities. So you would be then covered by AB 1482, which is, you know, much more generous. In fact, they don't even call it rent control. I think in the legislature, they call it something else, rent limitation, something like that. But it is, you know, 5% plus the complete consumer price index for the local area. But it cannot exceed 10%. So that's the cap is 10%, but it has been 10% for the last year. And that I think comes out in April. But AOA has that information on its website in terms of what the AB 1482 limit is. So, you know, be sure to check there. And I think, like I say, that was, I could have added more cities if I'd known how quickly this was going to go. But I think that's it for the moment. So I don't know what to do, Jeff. What do we do? So I'm going to stop sharing and let you take over.
What do we do? What do we do?
So,
hey, you know, it can be well organized, and we don't have to sit here for an hour.
well, I think if people that, you know, want to have a copy, you know, of course, I'll provide this to you guys, and members can reach out because, you know, it is a pretty handy guide. I mean, I learned some stuff. That thing about having a rent increase license from San Francisco, I somehow just completely escaped my attention, you know, and I kind of make it my business to stay informed, you know, so I'm a little surprised about that one. But so, you know, I genuinely appreciate your appreciation of my contribution here, but sometimes it does me good too. So, you know, it makes me a more informed lawyer, which makes me a better lawyer for my clients. So,
right.
And AOA members, which are sometimes the same. So,
yeah, that's right. Hey, thank you so much. Now, guys, this is the time to get your questions in. YouTube, Facebook, you know what to do. If you're on AOAUSA.com, there's a blue help button on the right side at the bottom. You can type your question in there and they'll get that to me. So we'll take some questions now. But guys, do you see how difficult they are trying to make this? They are trying to trip you up.
Well, in some cases, it seems like that. You know, in terms of the secret requirements that, you know, again, statewide would not be necessary ever, and not even under AB 1482. So, but it's just, you know, knowledge is power. You know, that's the thing. You know, you just got to know what you got to do and make sure you do it. So, yeah.
Right. You know, we were just had a trade show just in the last week or so, and one of the AOA members came up to me, and his eviction case was thrown out because he hadn't given the security deposit interest. And, you know, that was one of the requirements there that you mentioned. And it's like, I just never knew it. And
there are way to find out.
Yeah. And I was 20,000 in lawyer fees and 60,000 in rent.
A really hard way to find out. I
Right.
mean, there's a second bite at the apple, generally speaking, by going back and complying and so
Yeah.
on. So it's really a delay, and a costly delay, obviously. And the attorney, may have to do a little soul searching there in terms of like making sure that, although, I can see where, I might not have asked the client, do you have your rent license, from San Francisco? So, and I do this, on a daily basis. So,
Mm-hmm.
we have a checklist, that we have to go through with our clients for every, particularly every non-payment case. If it requires that the tenant's deposit interest has been paid, annually, you got to make sure that's been done. If it's a Oakland notice, has the wrap notice been provided, and what's your evidence of that? These are just checklist things that, every client has to go through and confirm. And if they haven't, then we adjust and step back and take care of the problem, and then, schedule the next opportunity to revisit it.
Right. And if you think about an eviction, it's so much less common than a rent increase. So this type of information
Well, yeah, I mean,
we need to
and
put out
and
there.
and if the rent increase is wrong and the tenant doesn't pay rent for a month, and you're doing an unlawful detainer based on that increased rent, if the rent increase was invalid, then the 3-day notice that demands that full month rent with the increase will also be invalid, and your UD will fail.
Right.
And so that's the kind of, deep background that the attorney is responsible for making sure has been discussed. And tenant attorneys, they're, the ones in this area, they're very savvy, and that's one of the first things they would do in discovery. Please provide proof that the tenant received the wrap notice, that kind of thing. So, it's just really attention to detail in most
Yes.
cases.
Yes, it is. All right. Paul on YouTube, thank you so much for your question. He's in Santa Clara and he's wondering how much he can raise the rent.
Well, I don't think Santa Clara, because again, I mean, I could have done every local jurisdiction, would have filled out the hour for sure, but I kind of got a late start because, like I say, I think my understanding of this came to me a little bit late, but I don't believe Santa Clara has its own independent rent control ordinance. But the easiest thing in the world, and eventually you guys won't need me. You'll learn how to self-educate. But I would just go to Santa Clara and type in. Well, I can do that right now, actually. Shall we? Otherwise, it's going to be the state version, AB 1482, which is
Right.
10%. And I'm pretty sure AOA has, that calculation in as part of its member services, which is because it won't be 10% every year. That was an anomalous year last year when the inflation rate was so high. But it's 5% and whatever the local, and that varies on your location. So I think AOA, I'm pretty sure, and Jeff can maybe confirm.
We do. We have a handy dandy rent increase guide. And if you log into your member account in the forms section under AB 1482, you'll see a rent increase guide, and it'll show you by area. And so depending which area your property falls in, then you'll be able to figure that out. So that again, that's for those of you that are subject to AB 1487 rent control, because there's those of you that are not subject to that, and you can raise it more than 10%. But that's only for those of you that have a house.
Thank you for noting that some properties are exempt from both local rent control. But so I want to add this. Yeah, there's no rent control in Santa Clara, so you're basically subject to the state version, and that is AB 1482. So check your AOA chart for Santa Clara, but I'm sure it's the Bay Area generally. But there's a state law called Costa-Hawkins, and it was passed in 1996 primarily to take on the issue of what was called Berkeley's vacancy control law. So Berkeley was the only city. Well, Berkeley basically started rent control in the modern era, and it had a provision that even when the tenant moved out, voluntarily or otherwise, the landlord did not get to set the new rent, whatever the market might have allowed. the rent board would set the rent based on factors that I don't recall, because in 1996, the state legislature passed something called the Costa-Hawkins Act. Probably Mr. or Mrs. Costa was in the assembly and Hawkins was in the Senate and so on. But it took aim at Berkeley, and it just prohibited any local jurisdiction from setting the rent on a vacancy. There were some exceptions, but if the owner terminated the tenancy for an owner move-in, for example, then they were not free to set the next rent until a certain period of time. So there were some restrictions, but basically prohibited the concept of prohibiting the owner from setting market rent for the new tenant. It did a couple other things, though. It also imposed a statewide prohibition on imposing rent control on single-family homes and condominiums. So if you had one of those, you would be exempt from rent control. Now, you would be subject to eviction control in almost every jurisdiction, although for a while, those properties were exempt both from rent and eviction control, but the state law only prohibits rent control. It does not prohibit eviction control. So every jurisdiction now applies eviction control, just cause ground requirement on single family homes and condominiums. So the AB 1482 is a state law. And I remember when I was first doing a seminar on it, I just sort of exhaustively researched the assembly notes, because the bill doesn't get passed in a heartbeat or in isolation. They do an analysis and presentations and legislative digest, and I couldn't find any reference to how AB 1482 was going to interact with Costa-Hawkins, because they're both state laws and they have equal dignity, so to speak. And so basically, my understanding has always been that AB 1482 could trump Costa-Hawkins, and it does, to the extent that it covers single family homes and condominiums, unless the tenant has been given notice. And you've probably heard me talk about this before, that the unit is exempt because it's owned by an individual or an LLC that's not owned by a corporate entity, basically, the mom and pop owner. But unless the tenant has that information, it's still subject to AB 1482, including the rent caps. So there's that. And thanks for bringing that up, Jeff. But
and with that Costa-Hawkins, we have something that just got enough signatures and will be on the ballot in 2024, correct? That will try to repeal Costa-Hawkins?
There's almost always an effort, and it usually fails in the legislature. But if it becomes a ballot, Prop 1, Prop G or whatever, voters could pass it and repeal. It's not a constitutional thing, but that effort's been going on for a pretty long time. And I'm not sure if the motivation of the people is just like they just can't stand to have single family homes and condominiums exempt from rent control. I've never really read the sort of the mission statement of the advocates for repealing Costa-Hawkins, unless they want to have rent boards allowed to set rents on vacancies again.
Yeah, I think they want vacancy decontrol. I think.
Yeah, well, people need to kind of well, again, that was a bridge too far for most people, and I assume it will still be, but I don't know. I haven't read the polls, So,
right.
But yeah, when you talk about advocacy as an organization, definitely, that's an area you want to keep an eye on and who to influence. But again, if it's a ballot measure, you can't really beat down on the legislative branch. It's got to go with advertising, because apparently that's the one that matters the most.
Right. So it's come up twice before, and it will be on the ballot this year again. And it doesn't have a number yet, but it was called the Justice for Renters. It's that one. So we're really, guys, we're going to have to be on our A game with that one. 2 other times we beat it. And this is what we did before. You guys can see that.
Vote on Prop 10 to save affordable housing. Wait.
So that's a yard sign. And we mailed that to everybody in a little kit like that. And we will do that again. So for each of your properties, you can put that in the yard and people can see that. and it's going to be another fight, and especially because of the way they named it. They named it so it sounds so
Well,
pitiful.
I
To
mean,
not vote against it, it sounds like you'd be a bad person unless you
it,
really
it,
knew
it,
the impact
the
on renters.
right, the art of presenting the proposition is most of the battle, really. I mean, I'm not sure how many people read the actual proposal. It comes in the mail, but I don't know how many people actually read that the actual proposal, or even the pros and the cons. I mean, I think a lot of people get their informed opinion based on the ads that fly around, right around the time of the election.
Yep. So we'll need to put some money in on that one, and we have the political action fund for that, and we've been trying to save our pennies for that, and definitely if you throw a buck in the jar there, it'll help us get the
Yeah,
advertising out there. Here we
small
go. More.
donations add up.
Yep. And more on those questions here. Can you talk about Alameda County, Fremont, Pleasanton, Livermore?
Well, again, I mean, I could have covered everything. I mean, but and that, like I say, might have taken the whole hour. But those are all. So Alameda County is a big county and it has a lot of cities, including Oakland, Fremont, Hayward. I think the Livermore, the other one you mentioned, and Hayward has a rent control ordinance. Fremont, I believe, has a rent control ordinance. I don't think Livermore does, but you can do the same thing I do,
Hey,
which is just
maybe
go in
we
your
could go to
browser.
round, or we could go to round two and kick it down the road a month or two and then come
Well,
back on
yeah,
and answer
we can
those.
do another one that encompasses those other jurisdictions. But again, you can also just go into your browser and just type in, for example, Livermore rent control, and something will come up. If the city has a rent control ordinance, it'll be an official website that you'll be directed to. Otherwise, it'll just be lawyers, with blogs that say, no, because if the city has an ordinance, they're going to have an official website that describes it.
Right. And we have Allison in Alameda, and she may be able to field that question for you.
Right. Well, Alameda is a city in Alameda County.
Right.
It confuses people a fair amount, and it does not, I believe. No, Alameda has its own rent and eviction control.
Yeah,
That's
they're
right.
separate. Isn't that
Right.
crazy?
Yeah. So the city of Alameda, yes. The county of Alameda, no. Although the county did, they had actually passed it and then reversed themselves. I mean, maybe they actually put it on a ballot and it didn't pass last November. But there was definitely an effort to make all of Alameda County subject to its own control, but it didn't pass. So as of
All right,
now,
Karen.
unincorporated Alameda County is free of local rent control.
Right. Excuse me there. All right. Yeah. So Karen, she asked, are you familiar with the additions to the new CA bills passed recently? I joined late, not sure if you covered it. And so this one, we only covered rent increases for certain locations in the Bay Area.
Mm-hmm.
And this one will be more of a legislative update. And that brings us to that February 16th landlording power conference, and we will cover that for sure at that point. And most of these things, some things may take effect on the 1st, but other ones they take effect in April, like April 1st. So the things that we need to know before then we'll have to address before we get there. And the
I mean, the
ones
only
that
thing I
are
can think of that was passed, of significance was the security deposit change,
and
but that
that's April
doesn't.
1st, right?
I think
To
it's
take
July
effect.
July 1st that it takes effect.
Hmm.
So it just limits renting deposits to 1 month, unless you're exempt as a mom and pop. Then
Right.
you can do 2 months, or unless the tenant is a active duty military, then it's only 1 month no matter what. So I mean, it is, a restriction, but again, for the smaller property owners, it's hardly going to be noticeable. Big corporate entities will definitely be limited.
All right. White on YouTube, resident manager. What is the max rent increase for month to month and renewals for South San Francisco in San Mateo County?
Well, we didn't cover South San Francisco, but I am pretty sure, and I'll do the same thing I just did for Santa Clara, but if it's not covered by a local rent ordinance, it's going to be the state law. So let me just see what I can quickly find on my magic device here. So All right, does South San Francisco have rent control? Um, oh, Sam, nope, I don't believe so. Nope, I'm not seeing it. Rent control by city, nope. Um, so no, from my quick search, South San Francisco, no, that does not yet have rent control, so you'd be subject to the state law.
Right. And again, when we talk about the things, what do you have to have in place? Again, you want to have that included in your rental agreement. All the AOA rental agreements have had it since 2019, where it gives you a spot to either declare that you're exempt or that you are subject to the statewide rent control. And so those boxes need to be checked. And if you
Right.
haven't checked that box, what you want to do is serve the notice, then also give them the addendum, and hopefully they'll sign the addendum too, because it's so late if you haven't done that. So check your agreement there on that.
Yeah, I mean, if you can exempt your property, I would.
Yeah. And those are for the smaller ones. Okay. So KM, are owner occupied duplexes still exempt from AB 1482?
Yeah, but it's you had to have been occupying it at the time the other tenant moved in. This is my recollection because I have I qualified and then I moved out and rented the other side of the duplex. And if I move back now, I don't believe I would be exempt. So I can check, but I'm pretty sure that it required that you be in occupancy at the time the other tenant took effect. So like in my case, I moved out. If I wanted to move back, I would not be exempt, although I was while I was there and had rented to a tenant in the other unit. I hope that's clear.
So they could email you on that since you're a little
Yeah,
bit
but I'm about 99% positive that that's the
99%.
rule.
Okay.
That you
Okay.
have to
There
have been in possession when you rent it to the other tenant.
All right. There we go. Resident manager. How much in advance do we have to notify tenants for rent increases in South San Francisco?
Same as would be required under all the laws that I'm familiar with, whether they be local or the state. It's 30 days if the rent increase is less than 10%, 90 days if it's more than 10%. But
Yeah.
unless you're doing something that's exempt or you're in a rent control jurisdiction that allows bank rent increases that you're imposing that exceed 10%, a 10% plus rent increase is kind of rare now. But if it's going to be more than 10%, you got to give a 90-day notice.
All right, Karen, good question here. Is interest required in all of California when returning security deposit money?
No, California. There was a push to add that to I think 1482. Because it went through a variety of changes and revisions. But no, there is no state law right now that governs security deposit interest. That's a local matter, and most of those local jurisdictions require that you pay the tenant the interest annually. Because as we saw in one of the, I think it was Oakland. I have to go back and look at my own slideshow, but if you haven't given the tenant their annual interest, then you can't do a rent increase.
Okay,
And I think that
Pamela.
was Berkeley.
Pamela, how much can I raise the rent in Napa after adding a bedroom bathroom to my ADU? And so the way this question is worded, I'm just not sure, because I wonder if the tenant was actually in the unit when they added a bedroom and bathroom. So if it was empty, you can go to market rate. But let's say, go ahead and answer the question for her in the case that they added a bedroom and bathroom to
Napa is like Alameda has a city called Napa, and then there's Napa County. So
Okay.
I'm just typing Napa rent control because I had not looked at that in advance. So Napa rent control rules and regulations. Napa rental assistance, family. So there is fair market rent payment. This is really for rental assistance. Yeah, I'm not seeing a rent control in the city of Napa or the county of Napa, but again, I'm just doing a quick search. So if it's not subject again to a local ordinance, then you're just under the state law, and that's that 5+ CPI increase. Yep.
Yeah, okay. So
And
Pamela does have a tenant in the unit. Thanks for giving us more information on that. So they endured all that noise and all that. They endured the dust and all the construction. And yeah, that really changes it too, right? I mean, it went from being maybe a 2 bedroom to a 3 bedroom. And if they're not subject to rent control, you can raise that more than 10%, but it takes the 90-day notice instead of the 30-day, like you had written in your presentation.
right, right. So
If it's under if it's just under regular California tenant protection ordinance.
okay. Hopefully that answered that one.
Yep. Hey, Richard, thank you so much again.
Sure. Like I say, it was good for me. So it makes me a more effective advocate for my clients and somebody who's now aware of a San Francisco requirement I just did not know. So,
Right.
like I
And
say, if
again,
anybody, I'll send
oh,
the PowerPoint to I guess to Allison. So if any of the members want to have it, because it is kind of a handy little
yeah, it is.
chart, I
Yeah,
think.
it was great. That was excellent. And some of you said you logged in late. San
San Anselmo, like
Anselmo. Yeah.
San
So
Anselmo's fire.
yeah, right. So they're looking at having starting some rent control there. Again, I just want to mention that for those of you that may have property there. And so
Yeah, I think they're debating it.
yeah, so they just had a meeting on Tuesday again. So if you have a property there, let's band together on that, and it'd be good to turn out at the next meeting and try to curb some of what they're wanting to do here.
Yeah, I don't know if they're gonna. I mean, if they'll require that, it be a San Anselmo citizen to contribute to that debate. Um,
Yeah,
but
oh, that's what I mean. People that are from there. You don't, I mean, it's, I don't want people that are not from there to come in, from halfway around the,
well, I'm pretty sure tenant advocates don't follow that same
I
restriction,
know,
but
I know,
you
I
know.
know it.
So, all right, well then, been a pleasure, and I'm here if anybody has questions later. And there's the AOA question and answer forum that I think you reach by going to the website, and then that comes to me, at least for Northern California inquiries. Somebody else, I think Dennis Block for Southern California, but that's fair enough. It's a big state, hard to know it all. So, I'm like my little corner. So.
Hey, and if you were benefited by this, please give it a like and share it with your friends just so that they can stay informed. There's these little things they're trying to catch you, and we're here to help you stay compliant and get the rent increase that you need to make everything work. All right. Thank you, everybody. Take care.
All right. Signing off. Bye bye.
Bye bye.